Good morning, everybody. My name is Ian McKilway. I'm CEO of Finishes and Interiors Sector FIS, and the date today is the 1st of December 2020. Today, we're looking at immigration. I'll be joined by Ahmed Ajina, who is from Seddon's legal firm and is a partner in the immigration department who deals with areas of business and private immigration. I'm also joined by Ian Cole-Wilkins, Chief Executive at the Indigo Group of Companies, who amongst other things manage payroll and CIS compliance. I'm also joined today by Nathan Raven, Head of Interiors at Recruitment Specialist Linkedin, and also by David Hauer of Bamboo Solutions, who provide on-demand outsourced project solutions. This is the first in a series of webinars focused on the impact of Brexit on our supply chain. Today we're focusing on the tightening around the movement of labour. Next week on the 10th, we'll be zoning in on the movement of goods and contracts. As a backdrop, in the autumn, the Migration Advisory Committee published their final report and the Home Office published details of the points-based system. In terms of reasons to be cheerful, the skills level, which Ahmed will talk to, was significantly reduced from RFQ 6+, effectively degree level, to RFQ 3+, which is what we'd regard as skilled workers in construction. But beyond this, the Home Secretary's interpretations have been pretty hardline and caused particular concerns within the finishes and interior sector. At the moment, FIS research shows that 30% of the market are already experiencing skill shortages, in part due to labour returning during the COVID era and not coming back. This is particularly acute in the areas of plastering and dry lining and ceiling fixing, and it rises to 40% as we look to some of the responses from larger specialist contractors. Those with greater than 50 employees. 62% of our survey response said they're concerned about the impact of this migration legislative landscape in January, and that rises to 74% for our largest specialist contractors. So the format of today is going to be a keynote from Ahmed, Ian, David and Nathan, and then we're going to go to a Q&A panel session. So I'm going to ask Ahmed to kick off to explain the system and what it means to employers. Thank you, Ahmed.
Good afternoon all. My name is Ahmed Ajina. I'm a partner and the head of immigration at Seddon's Law LLP, and I've been kindly invited by Ian and the FIS to discuss the new UK points immigration system and the impact that is likely to have on employers and EU nationals and non-EU nationals moving forward. So the new immigration points-based system will come into place from the 1st of January 2021 for workers. It's going to introduce a skilled worker visa, which will replace the Tier 2 general visa. And the new immigration system and the skilled worker visa applies to both EU citizens and non-EU citizens alike. In terms of EU nationals who are in the UK before the 31st of December 2020 will not need to apply under the new immigration system, provided that they apply for pre-settled or settled status by the 30th of June 2021. The pre-settled and settled status is a very straightforward application. EU nationals could do that online or by downloading an app on their phone. They literally fill out a few questions on the form. It's very user-friendly. They then upload a digital photo of themselves, and they're required to send in a passport or an ID document into the Home Office or scan it via their app. And the Home Office will be in touch asking for specified documentation to prove that they meet the requirements. The application process is usually processed within 2 to 4 weeks. Just briefly, the difference between pre-settled and settled status is that any EU national who has come to the UK before the 31st of December 2020 will automatically be eligible to apply for pre-settled status. That gives them the right to remain in the UK for a period of 5 years and benefit from all of the advantages that EU nationals had prior to Brexit coming into force and the new immigration bill. EU nationals will be able to apply for settled status after completing 5 years of continuous residence in the UK. So if by the 31st of December, they haven't completed 5 years and they apply for pre-settled status in the first instance, and then they apply for settled status once they complete 5 years. If, however, they have completed 5 years residency before the 31st of December, they apply for settled status immediately. That means that they were able to remain in the UK indefinitely. They would only usually be able to lose that settled status if they've remained outside the UK for a continuous period of 5 years, and they'll be able to apply for British citizenship 1 year after obtaining settled status. If EU nationals do not apply for pre-settled or settled status by the 31st of December, if they do not come into the UK by the 31st of December, then they would, or do not apply, if they have come in by the 31st of December and have not applied by the 30th of June 2021, they would need to apply under the new immigration system, which is the skilled worker visa. I'll just come back for some reason. Okay, there we are. So the requirements for the skilled worker visa are as follows. I'm going to go into them in more detail in the next slides, but there are 4 requirements in total. The first requirement is that the employee must have a job offer from a licensed sponsor. It can't be from any employer. It has to be from an employer who has obtained a sponsor license from the Home Office for the purpose of sponsoring the work permits of foreign nationals. The job that they're offered must be at a certain skill level. The salary for the job must be at a certain level as well, and the employee must meet the English language requirements. So I'm going to go into the 4 requirements in a bit more detail. So the first requirement is the licensed sponsor. So to employ foreign workers under the new immigration system, the employers must first apply for and obtain a sponsor license. The application for the sponsor license usually has a turnaround time of around 8 weeks. It's worth obtaining professional advice on putting together a sponsor license, as there is a suite of documents required by the Home Office. So they have a list of mandatory documents that need to be submitted with the application. The documentation can be found online on the Home Office's website, and I'll be happy to circulate that through Ian following the webinar. But generally, it's to show that the business for the company is actively trading, that the business has the relevant employer liability insurance, and that it has systems in place to maintain that employee checks are adequately carried out. Once employers obtain sponsor licenses, they're expected to comply with various duties, including record keeping, ensuring that they have systems in place to comply with them. Otherwise, they risk having their sponsor license revoked. If the Home Office finds through routine unannounced visits to the place of work, if the Home Office were to find that those record keeping checks and systems in place do not meet their requirements, then the sponsor license can be revoked. Moving on to the appropriate skill level, the job must meet at least level 3 of the regulated qualifications framework, and this has been reduced from level 6. The following jobs relevant to members of the FIS meet the relevant skill levels. These include carpenters and joiners, plasterers, floorers and wall tilers, construction and building trade supervisors. It's important to note that dry lining and system installers do not currently meet the appropriate skill levels, but I know that Ian and the FIS are lobbying to have dry lining to be moved under the plastering skill level to make sure that it meets the requirements. So I'm sure he'll touch on that in more detail in the questions and answers section. The next requirement is the appropriate salary level. So the overall minimum salary for people under 26 is £20,480 per year. The overall minimum salary for people over 26 is £25,600. Employers will have to pay the minimum salary or the going rate for the job as classified by the Home Office. So the going rate for the jobs just mentioned earlier are as follows. So for carpenters and joiners, that's 22,300. For plasterers, that's 24,300. For floorers and wall tilers, that's 21,800. And for construction and building trade supervisors, that's 31,400. The above figures are based on a 39-hour week. If the person you employ is contracted to work longer or shorter hours, the going rate is adjusted pro rata. Employers can pay employees at the lower rate if the position is on the shortage occupation list, or if the employee holds a relevant PhD. That means that employers could potentially pay their employees only £20,480 per year if that position is on the shortage occupation list, or if the employee holds a relevant PhD. The next requirement is the English language requirement. If the employee is not a national of a majority English-speaking country, they will need to meet the English language requirement by one of the following ways. So the first way is by completing the Home Office approved English language test at B1 level. That can be done in the UK or it can be done abroad. The employee has obtained a bachelor's degree in the UK, or the employee has obtained at least a bachelor's degree in another country, for example, their country of residence, and it's been validated by UK NARIC to be equivalent to a UK bachelor's degree. And also, that degree must have been taught in English in order to meet this requirement. So it's either one of the three options there to be able to meet the English language requirement. How much will the skilled worker visa cost? Okay, so per employee, the following fees would apply. The first amount is the sponsor license, the immigration application fee for sponsor license. It's important to note here that an employer is just required to have one sponsor license, so they don't apply for numerous sponsor licenses for each individual. So once they have that sponsor license in place, they're able to employ as many foreign nationals as they please, because there's no cap on the number of foreign nationals that they can employ, but we'll go into that in more detail. They have to pay the certificate of sponsorship fee, which is £199. The immigration application fee for skilled worker visa, so that's on the basis of a 5-year visa. The immigration health surcharge, £624 times 5. And the reason why we put 5 is because employees will need to work under the skilled worker visa for a period of 5 years in order to qualify for settlement. Once they qualify for settlement after completing 5 years residency, they'll be free from immigration restrictions. So that means that they can work for numerous employers. They won't be bound by the conditions of their skilled worker visa. And there's also the immigration skills charge, which the employer would need to fork out, and that's again £1,000 per year. So we put it as £1,000 times 5. So the total fee, you're looking at around £10,075 per employee that you're looking to bring in, obviously minus £536 for the sponsor license fee for any subsequent employee that you bring in. Okay. Some of you and your organizations may already have the tier 2 work permit, work permit employees currently employed. So it might be helpful to know the differences between the two. The tier 2 work permit visa is now defunct as of today. But people who are under the tier 2 work permit visa can continue to work and live in the UK under the tier 2 work permit until they qualify for settlement, which is after 5 years of being under this route. So the first difference is that the minimum skill level has been lowered from RQF level 6 to RQF level 3. The minimum annual salary has been lowered from £30,000 to £25,600, potentially down to £20,480 if they're a new entrant, or if the employee holds a PhD, or if the position is on the shortage occupation list. There's no resident labour market test, meaning the position does not need to be advertised for a minimum period of 28 days. That means as soon as you identify the employee, you could offer them, you could give them the job, issue them the certificate of sponsorship, and they can apply for the visa directly. So there's no cap on the number of employees as well. So that means usually the Home Office specify an amount which varies on the number of tier 2 work visas that they issue per month, but there's no cap on this from moving forward. There's also no 12-month cooling off period for employees. So where an individual was on a work permit visa and then they left the UK and they wanted to come back, they would need to wait a 12-month period before they're able to reapply under the old scheme. But under the new scheme, if they were to be employed and they left the UK, they could apply immediately after going back to their country of origin, and then they can come back to the UK. So there's no cooling off period. There's no 6-year maximum length of stay previously, people under the old regime, the Tier 2 work permit, could only be in the UK under this residency for a period of 6 years maximum. Now there's no maximum period, so individual could potentially remain in the UK for 7, 8, 9, 10 years under the skilled worker visa route. That's quite uncommon because they'd want to apply for settlement, but if for whatever reason they'd have to go back and then apply for a new skilled worker visa route, they could add up the total years, and it can be over 6 years. Employees already on the Tier 2 visa can now switch into the skilled worker visa. So if you were to have any employees who are under the Tier 2 worker visa, they can now switch into the skilled worker visa under the more beneficial terms and conditions associated with the visa. And the good thing about this is that any time spent on the skilled worker visa will count towards the requisite 5-year period of the Tier 2 visa. So for example, if they were in the UK for 3 years on a Tier 2 visa, they can then switch into the skilled worker visa for 2 years, and then they can apply for indefinite leave to remain or settlement after completing 5 years. So the clock doesn't start again from them getting a new skilled worker visa if they had previously been on the Tier 2 work visa. That's a brief insight into the new immigration system in place. I'm happy to take your questions in the question and answer session. If you do have any questions, I've put my contact details down. And I believe that Ian's going to circulate these slides. So please feel free to get in touch should you have any questions regarding the new immigration system or settled status or any immigration related inquiries.
Thank you, Ahmed. So whilst we switch the presenter, I'm going to introduce you to Ian Cole-Wilkins, who's going to be doing the next presentation. We've been working with Indigo for some time now, and I have to say I've very much enjoyed the interaction we've had with Ian and his team. They're real experts in the CIS and payroll systems around construction, and have been providing us with immense support over the past few months. So it's a quick thank you to Ian and his team. I don't know, Ian, is your microphone up? Are you ready to go?
I believe so, yes, and thank you for that kind introduction. I'm also joined by my colleague James Smith, who's helping me with the slides, as technology, despite us having some technology subsidiaries, isn't my forte. So I'm going to cover off 2 areas. Generally employment models, your right to work responsibilities. Before I do that, I'm just going to touch on what the Indigo Group does, so it gives a bit of context as to why we're talking about these matters and some of the practical aspects of that. So the Indigo Group has a range of companies within its group, several different companies, all doing different things. Been established since 2007, a reasonable sized business, turnover just over 300 million a year, although that's come back a little bit through COVID. Engaging over 500 clients, around 10,000 contractors on a weekly basis. Our flagship product, and most of what I'm going to talk about today, is our supply chain assurance platform. It's a platform which allows visibility and transparency through the supply chain, and hopefully you'll see through this presentation how that fits in, particularly with the new rules and other aspects. If you could jump on the next slide, please, James. So, as you'll see from Ahmed's presentation, post 1st of January 2021, things are changing significantly, and then the obvious sort of onward sort of run into June. That includes right to work. Now, whilst I've no doubt all of you guys have been carrying out your right to work checks correctly up to date, there has been almost a flexibility or sort of disregard whereby if someone's a European worker and they can demonstrate that, you didn't have to be overly diligent, because you'd be probably comfortable with the fact they would have had the right to work. Now, there's more checks in this instance now. First of all, the settled status and pre-settled status, which I just talked about, but also, especially, you're now needing to check, whether they had the right to work, and we will see an influx of non-EU nationals as well, trying to fill some of those gaps. Long and short, it means the compliance burden is massively going to increase. We'll see a couple of things happen there. First of all, on sort of the good side, we'll see a rise in professional employers organisations, which I'll touch on in a moment. But in short, they're sort of packaging agencies or packaging entities whereby they'll deal with all the compliance aspects for you. On the other side, we'll also see the rise of gangers and, in particular, sort of uncompliant aspects, whereby people will because of desperation through shortage of labour, may lean towards opportunities and structures that may be not fully mapped out. Self-employment does remain a possibility, although far more difficult, but certainly where someone does hold settled or pre-settled status, the considerations for that are exactly the same as whether the UK national. Where someone's coming through on a skills-based system, as yet it doesn't appear to be any provision there, but things are moving in that space, and we don't have a final deal as yet. Things may move just before the end of the year, although increasingly less hopeful. As Ahmed touched on, the sponsorship routes will become more common, and the other area we want to consider is just how that these pieces of legislation don't operate in isolation and that they actually interact with each other, and that there's almost a domino effect again, which I'll touch on a little bit later. But the overriding message coming from us will be to look, the first step is to know who's on your supply chain, map your supply chain out, because then you can start to deal with the whole raft of compliance issues, not just each individual issue as and when they arise. If you can nudge on to the next slide, please, James. Sorry, guys, I'm just conscious that, as you can probably tell, I've got quite a thick Welsh accent. I'll do my best to slow down so that you can understand me more fully. I just touched on in the previous slide the domino effect, and whilst we're focusing on right to work, how it starts is that if someone fails a right to work check, the likelihood of them being a modern day slave increases significantly. That then brings other considerations. The likelihood the national living wage is not being met. The Criminal Finance Act, which has an obligation whereby you knew or should have known that tax avoidance was taking place or tax evasion was taking place, and that liability can go up the chain to both you and to your client. And furthermore, the health and safety considerations. If someone's a modern day slave, or if they failed right to work checks, the likelihood they'll report a health and safety event or understand how to deal with a health and safety event is far more less likely. But ultimately, it's your commercial reputation, in that the damage of having illegal workers on your site can damage both your reputation, your client's reputation, and just go far wider. On to the next slide again, please, James. So, as we were saying, the message from us becomes to sort of map your supply chain, and in some way, sort of, whether it's through a system like we offer or whether it's through an individual person on a manual basis, just trying to track down. And this is sort of a illustration of a supply chain here, whereby it isn't particularly large, but it's just a very common structure. And as you can see, the interactions with how people throughout the chains aren't particularly well understood. So our first message would be, look, get them into clear lines of understanding, that whereby you can see how they interact, and then you can see how the compliance failures and tracks track through. So if you can just on the next slide, James, you can see that the domino effect we're talking about there is whereby that if there's a modern day slavery issue, it's likely stems from a failed right to work. It could be coupled with a CSCS card expiry or wider insurance as well. But the message I'm trying to sort of push home is that right to work, yes, is a massive consideration, but it doesn't happen in isolation. That where there is a failure right to work, there's likely to be other compliance issues as well, in particular modern slavery. And again, not to John James. So on right to work responsibilities in terms of what you actually need to do. Well, the first thing is it legally applies to people you employ. That said, our advice is that you should carry out right to work checks on both your employed and your self-employed and other entities within your supply chain for the reasons I've just discussed, because it does lead on to other areas of non-compliance which can become your obligation for both employed and self-employed. So what do you need to actually do? Well, the government guidance is a little bit fluid at the moment, and there was a relaxation throughout the COVID period that they were allowing some further digital aspects. But ultimately, what you're trying to do is create a defence to show that you've taken reasonable care and due care, and that you've made an effort to check, and that you've attempted to be compliant. So you need to obtain original versions of an acceptable document, typically a passport or other sort of forms of ID. That can be managed both digitally and sort of on a traditional method. On more traditional methods, we would then consider wide areas of legislation such as GDPR and how you manage and control that data as well. You need to check the document's valid. Now, you can either do that through training of staff, or there are certain online systems. One of our subsidiary companies, Credus, is an AML and KYC business which authenticates passports and goes as far as reading the NFC chips as well. And then you need to maintain and retain a clear record and show proof that you've done what you're supposed to have done. Get anything go on, James? So what happens if you get it wrong? So there's a civil penalty of up to 20,000 per legal worker. Now that can be mitigated again through showing that you created due care or a reasonable excuse, and that you have that statutory protection. In more serious cases where you willfully knew and intentionally employed a legal worker, it can carry prison sentences up to 5 years and an unlimited fine, albeit those cases are rare. But we will see an increase as labour shortages occur post-Brexit. You can disqualify as a director, and as I talked about earlier, ultimately it's the commercial issues. It causes disruption on site, causes delays, potentially penalty clauses to kick in, and ultimately a very awkward conversation with your client as to why you had illegal workers on site who ultimately won't have been insured, will present a health and safety risk, and will damage your relationship with that client.
I think, Ian, it's fair to say, isn't it, that we're expecting more clampdown through the supply chain on this, because there's I suppose in the economy there's less places where modern slavery is likely to be operating at the moment because of the quieter aspects in other industries because of COVID. So the police force is the same size, and construction is an area they will be clamping down on.
Yeah, and there's the new joint merged body, the GLA and the Labour Inspectorate are forming a joint body as well. But we've seen the textile up in Leicester that modern day slavery is a very real issue, and it's an issue we're going to see a lot more of. Even from Ahmed's presentation, you can see the new process, the skills-based system, is complex, it's time-consuming, it's costly. So especially sort of smaller entities who quite often with no intent can be lulled into self-confidence that someone's done the checks they should have. Ultimately, the message has got to come back is you need to do your checks, and you need to show a way that you've done your checks. You've got to be able to demonstrate that you've taken that due care. Government legislation more widely has very much changed stance in that liability used to flow downwards across a raft of pieces of legislation. It's not for today's sort of topics, but IR35 being one. It's completely changed stance. The government has been going wise to the fact that people able to pay sit further up the chain, so they're pushing liability back up the chain to contractors and their clients, and clients are then taking commercial remedy to push it backwards to the subcontractors or to the contracting entities as well below them. So it's about just getting it right from the start. Yes, there'll be shortage of labour, and yes, there'll be sort of a danger of people wanting to cut corners. But if you've got that evidence bank and that you can show that transparency, that you've done what you should, that will offer you a defence.
Thank you.
Let's go to the next slide, James. So the key point is the all UK's employers' responsibility to prevent illegal working. Now, I use that in that wider sense, in that it's not just those you directly employ, it's those who are on your supply chain, because the engagers of illegal workers, especially if they're gangers or less established agencies, for example, will disappear quickly if there's a risk, and you'll be the one left with the issues, and ultimately the press, especially if you're a larger entity or if there's a health and safety event attached to it, won't consider who was the direct actual employer or whether that person was employed or self-employed. So those checks are a must from the start. I touched on before, the ability to work legally is a key driver of illegal immigration and ultimately modern slavery. And it's, I can't stress enough that that is an issue which is rife for construction. We're seeing more and more of it. But also then it's the knock-on effect it has to your lawful workers, that it's driving down rates for both the contracting company and the guys that you engage, whereby we're seeing issues of tax evasion, breach of national living wage, and the danger is that the sector gets tarred with the same brush, and therefore checks from HMRC and wider Home Office checks become far more prevalent because the sector doesn't look like it's doing what it should. Next slide, please. Okay, so switching stance just a little bit more, I touched on sort of sponsorship organisations, or Ahmed did in more detail, and then what we think we'll see the rise of. We do think we'll see the rise of professional employment organisations. Now, in some part, that's a rebranding and rephrasing of an umbrella company. Now, although it's a return to what an umbrella company originally should have been, which is an entity to employ people and manage all the compliance tasks and make employment more flexible. Unfortunately, by various parties, umbrella companies have been abused over the last 10 years, and particularly the lower paid, with lack of clarity over who's being paid what rate and other aspects. So we do think with the industry will do a bit of a rebrand and move to sort of PEO. So it's certainly something we're doing for those reasons I've just described, because we do want to create distance from sort of the unscrupulous umbrellas. They will become more important as engagement becomes more complex. But if you are outsourcing to PEO or someone else, you can't take their word for that they've done everything. You need some way to check that they are doing what they should do, because ultimately that obligation will come back to you. It's all about looking through the chain and keeping that transparency. It's a word you've heard me use over and over again today, but it is about that transparency through the chain and just understanding that all parties are maintaining the standard that you expect of your business and that your client expects of you. So typically the areas they work on for you will be the payroll, the packaging for the skilled role-based, and also then the onward HR, payment, the safety mitigation services as well. If you can just nudge on, James. So I think that covers, like I said, a bit of a whistle-stop tour from us. James' his email address is there, who's ably moving the slides on for me. If anyone has any additional questions, please do send them through to James, but more than happy to take questions at the end, and it's probably a bit more comfortable doing it on a sort of free-form basis.
Yeah, thank you, Ian. So as we move the presenter across to Nathan and David, clearly the employment models within the finishes interior sector, we rely on employment, labour and subcontractors, but a big part of that flex in the supply chain is provided by the gang and agency workers. So we thought for the purposes today, it'd be good to get Nathan and David to give us their take on what they're seeing on the ground out there in the marketplace at the moment, areas that they're concerned, and how their part of the supply chain is reacting to this changing legislative landscape. So over to you, Nathan.
Yeah, thanks for that, Ian. Yeah, so wanted to sort of open up. I'll briefly introduce sort of what we do and how we're relevant after this slide, but just to touch previously on what the other two guys have said there. But it's an ever-changing environment, Brexit, at the moment. We're seeing massive changes happening, as officially of the 31st of December, how the rules, the regulations and legislation around that is changes daily. I mean, Ian actually sent us an email this morning which showed an update from the government having changed some files, moved to new places. So it is literally changing on a day-to-day basis. So staying in touch with your legal and your compliance entities is something that you should be doing all the way through. It's something that we're doing and something that we're going to continue to do. So I just thought I'd get that out there right in front before we start. So moving into Lignum Group and sort of why we're here, I suppose. Lignum Group were started around Lignum Recruitment, which is where I head up the interior sector. We are headed around three main sectors, subsectors within construction, steel, facades, and our interiors division, looking at dry lining, suspended ceilings, partitions, joinery, flooring, and fit out. We then have Bamboo Project Solutions, which is what David is heading up, who will speak shortly. So Bamboo is an outsourced project management function. Office design, project management, labour supply as well. We have Cedar Retail and Development, which is also another recruitment firm, and then Branch Tech Recruitment there as well. So I'm going to pass this over. So this is our potential solution for where we're at in a minute. I'm going to pass this over to David. So David, if you want to pop yourself on, I'll put my camera off, and David will run through sort of our potential solution going forward.
Seem to have lost David there, Nathan.
Does look like we've lost him, doesn't it? Yeah, is he still? Oh no, here he is. Sorry.
Guys,
Two different offices, sorry.
bit of a delay here, guys. Thanks for letting us on here, Ian, today. Just to have a quick talk about what we do. I suppose Brexit is the fly in the ointment at the moment across the wider European Union. Just to give you an idea, we would trade with numerous groups of contractors across the wider EEA, and in some terms across the EFTA, the European Trading Association. We would go down as far as the depths of Eastern Europe to get supply and contracting teams on board with us, and again vetted to the relevant standards of the companies that we deal with. We do see a lot of the contracts that we're engaging with now with main contractors on behalf of our clients. They will have an indemnification clause against any tax liabilities in the country of origin where the workers are coming from, or in the country where the work is being executed. So that is a common trait coming across all contracts. We again would do European to European contracts. We also source in the UK and Ireland large quantities of people, again in the interior steel and external facade sector. At the moment, we consult on our projects, agreeing square meter rates and mainly lump sum rates for engagement with our clients' contracts. We would use one of our entities across the EEA, and we would contract out works packages requirements to EEA contractors. Those EEA employers would post the workers under contract terms to the countries where the contract is being executed. A lot of work going on in data centers across Germany, across Amsterdam, the Netherlands, Central Europe. We would be very active in those environments. We presently operate under the A1 process, and then ensure that all the workers are paying their tax and liabilities in the country of origin. So the workers are there for the duration of the contract, and then they return home when the contract is completed. We ensure that you're covered from a legal and compliance standpoint with our checks, and we will file that to the main contractor on your behalf. I suppose one of the big steps for us is sitting down in terms of a consultation with your quantity surveyors, with your business management team, and ensuring that we can find a place to source workers. Again, we are talking about Brexit. Nathan will stand here and he will tell us that a lot of the workers we get still come from the UK, within the UK, supplied to the UK. So we are not saying that it's all going to be EEA either. We know that there's going to be free trade agreements, and I think just in light of what Nathan said at the start, we do expect some sort of last minute deal from the European Union. Now, that's an expectation. It's not a fact right now, but it's something that we think is going to happen because there's an immense amount of trade out there being done that will get hampered by Brexit. The model we currently use across the EEA is to supply labour. Currently, it's unclear as to how the posted worker model will be affected by Brexit. If we get a free trade agreement on services, it may not be affected. I know I've been on webinars for the Transport Association, so again, it's similar to a truck driver executing his services in the UK. Is that driver going to be let in to drive the truck, or are we going to have a change of driver coming into the UK and somebody else drive his truck? Again, if I'm selling a product into the UK and I'm paying customs and excise duty on that product, will I be allowed to send somebody in to service and supply that product and install that product? So a lot of those things are up in the air, and I don't think there is a definitive standpoint on that yet, but we will be keeping the FIS and our wider network up to date on those items as they come up, considering that we have a pipeline of projects booked for next year. It's something that we're watching very closely. So ensuring that we're up to date legally and in line with current legislation will be a continual part of the process of communication, as will keeping the FIS informed of the changes in the model in its process. One of the big things that I will say at the moment is we have done about 30 million euros worth of projects in the last 5 years across Europe. We are very adept of taking your contracts and being able to execute them with groups of labour, skilled labour across the European Union. And again, I would see the wider amount of contracts from UK employees or UK contractors who are contracting outside of the UK, but within the European Union, we can still absolutely offer really good solutions for that. As we said, Brexit is the fly in the ointment at the moment. So we will keep you guys posted as to what the future solutions are on that, if any.
Brilliant, thanks for that, David. I'll just get myself set back up there. Yeah, so one of the points David touched on was sort of, you know, talking about UK-based labour and problems that agencies are currently facing. So we have sort of a boots on the ground sort of view from this, I suppose. A lot of the guys that we do interact with are labour masters who reside from the EEA, and you know, we're in regular contact with these guys, and they're already starting to see, you know, this problem happen. A lot of the guys have gone home earlier than expected due to COVID, unfortunately. You know, whether that just be go back to visit and decided not to come back. And there's a particular shortage down at the moment in the southeast of England. I don't know if anyone on is currently based down there with their projects down there, but there seems to be a massive amount of the workforce down there is Eastern European, and a lot of that workforce is gone, and the likelihood is not coming back. And the sort of the feeling that we're getting from the guys who are controlling these gangs of fixers, tapers, jointers, whatever it may be, is that it's only going to get worse. I mean, we may have a few months going into next year where things don't quite settle. You know, people have until July to sort of make the decision on sort of where and when they want to do. But the general feeling is that it will continue to get worse as 2021 goes on. So it's about getting ahead and trying to find these solutions. Now, one of the phrases that Ian likes to use is in uncertainty, the unscrupulous get a foothold if hope clouds diligence, and that's absolutely spot on. I think, you know, it's all good and well having solutions. A lot of people will have solutions. It's about being cautious, being wary, making sure that, you know, you're checking these with proper due diligence, because there will be enough of them going about. So, you know, some key points really is making sure you're doing your checks. And I don't want to teach people to suck eggs. I'm sure they do, but when it comes to, you know, to checking yourself financially, checking yourself legally, and checking yourself contractually that you're covered, whether that be speaking to the likes of us, whether that be speaking to the likes of Indigo or Seddons in that respect, get reference checks, get background checks, and just make sure that you do stack up legally, because as you know, Ian from Indigo alluded to previous there, a lot of this will fall at your feet. A lot of it will pass to you, and if things don't go to plan, you could find yourself in a little bit of trouble. So just make sure that you are doing those checks and that you are covered properly.
Brilliant, thank you, Nathan. So this is the time we're going to move across to the Q&A. I think that's your slide done, is it, Nathan? I haven't jumped in early, have I?
Yeah, we're done. Yeah, sorry, yeah. Yeah, we're finished up.
Thank you for that. So if you've got any questions, please do type them in. And you can see, hopefully from what you've heard, you can see why FIS remains concerned about the immigration situation. I think some of the data that we've seen from the Construction Products Association that put some numbers around this tells us that 54% of EU-born construction, the construction workers not born within the UK, so EU-born construction workers employed in London, has dropped by 54% since 2018. So we have already seen a large attrition accelerated this year due to COVID. Now, I'm led to believe that figure should correct a little bit in the final quarter, but January remains quite a big unknown, and we're expecting a cliff ledge, not a cliff edge, so a slower return in the new year. So definitely concerned. The key messages here is that January is a cliff ledge, not a cliff edge, because we do have some time to correct until June. So we've got the final deadline for getting settled and pre-settled status is June, and we have provided some guidance and information on our website about the kind of questions that you should be asking your workforce at the moment in order to prepare for this. So if I could ask the panel members to put their cameras back on, we can run through some of the questions here. Brilliant, there we all are. What a handsome bunch. So the first question I've got is, we've got this ride-in period in settled and pre-settled status. What should companies start doing right now? Shall I ask that to Ian as a first off?
Yeah, so it's an area of work we've been doing quite a lot in. So without trying to hammer home our platform, the platform effectively allows you to check that someone has applied for pre-settled status. So whether you're on board in new labour or whether you're engaged in your current existing workforce, you need to ask the question, have you applied for either pre-settled or settled status? And ask for the share code, because the share code can be checked either through a commercial piece of software like ourselves or directly with the government, and kind of those checks and keep a record of who has applied for pre-settled and or settled status. So that's ultimately is the first thing, is engage with your workforce, talk to them, ask the question. For those who haven't yet applied, the clock is ticking and they need to sort of apply sharpish.
Thank you. Is anyone else coming on that?
Sorry, just sort of elaborating on that, Ian. One of the things we've sort of have found is that COVID has delayed a lot of people's applications because it's created uncertainty as to whether they want to stay in the UK, and the fluctuation of exchange rates and other aspects as well. So, it will be about talking to and reassuring your labour that there is work for them as well, because that's been a big part of whether people are going to stay or not.
That's an interesting and an important point you raised there, Ian. It's the fluctuation of exchange rates and the potential for inflation within contracts that's particularly concerning. So it's not just about impact on programme and availability of people, it is the potential inflation this will drive through contracts and the pressure this is going to put on the specialist. Ahmed, have you got anything to add to that?
Yeah, I'm just echoing what Ian said. It would be good practice, to compile a list of all of your employees, their backgrounds, whether they have applied for settled or pre-settled status. Perhaps advise the employees in terms of if they have any family members, contacts, associates, relatives in their country of origins, to tell them that if they do want to live in the UK post 1st of January 2021, they should enter the UK by the 31st of December, because ultimately it's in the business's best interest to get as many EU nationals as possible to be under this status, which gives them the flexibility of work. And I mean, it's unrestricted in terms of the work that they can carry out. It could be any type of work, as long as they have this scheme in place. And I mean, perhaps incentivize the EU nationals who have yet to apply and say, well, look, we'll do the work. I mean, we can do it within our own HR department, or we can instruct the legal firm to do it. Because like I said, it's really important for both, not just the EU nationals, but employers as well, to get all their staff under this settlement scheme, which means that they wouldn't need to apply the new immigration system.
Thank you. We've got another question here, which is the skilled worker RFQ3 minimum qualification higher than NVQ2, which most tradesmen hold? I think probably that's more one for me, I guess. Ahmed, help me out if I steer off the path. Yeah. The government have published a list of what they would regard as skilled workers, and it's loosely based around NVQ level 3, so RFQ3 plus, loosely based around NVQ3. The particular challenge in our sector is they've based the determination on standard occupational classifications. So plaster, as Ahmed put in his slides, plastering, carpentry and joinery are all deemed to satisfy the RFQ3 plus qualification requirement. Dry lining, ceiling fixing and partitions installation unfortunately are classified, and I can't remember the number, but it's sort of a not classified elsewhere category. And that whole category is being determined as an RFQ as lower than the RFQ3, so not part of that skilled worker route. That is something challenging the Home Office about, and we've got another meeting with the Home Office on Friday. There's two issues there. One is they've not gone into the granularity within that catch-all category to look at the individual occupations they're in, and also they've based it on the 2010 standard occupational classifications, and in the 2020 dry lining is actually classified by plastering and therefore should be on the skilled workers list. So we are taking those back with the support of Build UK. We're taking those back to the Home Office, and we have another meeting with them on Friday. So that's something we're picking up, but it's clearly something that creates an additional clear and present danger for our sector, because those mandatory 50 points are more difficult to attain within the interior system. Let me just sort of double check the questions coming in there. The next, I hope that answers the question. Was that sort of captured it from your end?
Spot on.
Yeah, thank you. In terms of that sort of actually answers the next question, which is if somebody's got a level 3 qualification but they're not on the RFQ 3+ skill shortage list, would they deem to satisfy? And I think the answer to that is no, because the occupation is not classified as a skilled worker. I mean, that's correct.
Yeah.
Then I've got, when can companies apply to become a sponsoring organisation?
Immediately.
Yeah, right now. Yeah.
Right.
We can circulate the list and the guidance on it to give the government their dues on that. They've actually published some decent data and quite an easy to follow process. It does take some time, and you do need to have the ongoing monitoring is the real key issue, and you have to consider, depending on the volume that you're engaging, do you want to be a sponsor organisation, or do you want to outsource that sponsorship, or you can outsource the management of that sponsorship as well.
Yeah. How long does it roughly take? Have we got sort of a benchmark at the moment, or is it just such a change in landscape it's impossible to say?
I mean,
well,
go on, Ian.
Yeah, go on, Simon. So we're kind of ourselves, and we're expecting that process not to complete probably until early February.
Okay. I mean, we've done. I mean, in the last month, we've processed 4, and the month previous to that, it was 3, and we found that it's taken around 6 weeks for the process to be completed, for to have the sponsor license in place. So what the process entails is that you complete an online form. Once you've completed it and you've made the payment for the application, it then gives you a link to documents that you're required to print out. The key officer, or the one user, needs to then sign the documents and then send that off to the Home Office with a list of the mandatory documents that they require. The Home Office then processes the application. If they have any further questions, they'll do so by way of writing, or if they want to carry out further checks, then they'll schedule an interview. And the interview usually takes place at the place of business. But what we found that during COVID period, they've skipped the interview process. So they've just gone through questioning. And then once you've given them satisfactory answers, they then issue the sponsor license, and they give you access to log into the SMS management system, which you could then go online and issue the certificate of sponsorships for employees.
I've got a doozy of a question here. That clearly costs are rising in terms of labour in this space. How can companies make sure everyone is allowing the right prices in tenders for this element? I think that's probably, I would say, amongst this, my biggest worry. That quite often the fluctuation clauses are struck out of the contract. So it really is a case of reviewing and looking to your contracts to see what your liabilities are in this space, and being careful about what you sign up to, given checking labour availability. If you're using agencies, labour agencies or recruitment agencies, if you are having a regular dialogue with them to find out where things are at. I don't know if Nathan Ahmed, maybe you've got something to comment on that. Oh, I think you're muted, Nathan.
Sorry. Yeah, so in terms of sort of getting out ahead of it and getting in front of it, yeah, absolutely. I think making sure that one of the things we always push is lead time, making sure that you've got as much time as physically possible to ensure you can can provide your contract. You can fulfil the agreements in your contract. If you require labour, then get out ahead of it, get it sorted, get it organised as soon as possible. Which obviously this is going to throw up challenges for that. It's going to make it more difficult to do that. But the more lead time you do get, the likes of ourselves, the more lead time you can give us, the more we can get things in place to guarantee that will be there and you'll be able to fulfil the need on the contract.
Just a nugget on top of that one as well, Nathan. We've had a lot of clients come to us now who have signed contracts for next year for work. They're actual live contracts. The work isn't taking place until February, March, April starting. They've signed contracts to state that they obviously would take ownership for the tax liabilities of the gangs that they have in Europe. Some of them are in the UK, some of them are in Europe, and they just need to be careful that those contracts are covered, considering the changes in Brexit that are going to happen. If you've agreed business last year as part of your pipeline, you need to just look at where the liability lies in your contract, particularly if you have a back-to-back contract with your main contractor. It's important because they will be pushing the liability down the road to their subcontractor, and the subcontractor should be pushing that down onto their labour gang or their contractor or whoever's doing the work for them.
I think there was a comment which I'll paraphrase for the sake of time, but when there was a CLC event hosted last year, one of the tier one contractors comment around who's going to bear the cost of this. His comment probably could have been paraphrasing, put your tin hats on, it's coming your way. So again, legal teams will have been looking at these contracts and will have been looking to push the risk down. So be extra careful and look for those landmines in your contracts. We're short on time now, and I've got a few questions. So if we sort of rattle through these, we've got this one definitely to Ahmed. If an EU national returns home for Christmas, how long can they be away without having to apply for a visa?
So I guess okay. So assuming that
home, how long before settled and pre-settled status sort of becomes revoked, type thing.
Okay. All right. So if they're in the UK by the 31st of January and they haven't applied for settled status, by the 31st of December and they haven't applied for settled status, then they can apply by the 30th of June 2021. If they have already acquired pre-settled status, then they can be outside the UK for a period of up to 2 years without losing the right to their settled status. And if they pre-settled status, and if they're outside if they hold settled status and they're outside the UK for 5 years, that's when they'll lose their right. So as long as they have the status in place, it's very flexible as to what they can do, and their absences from the UK.
So it doesn't cost them anything to get settled status, does it? I mean, so
No, it's a free service.
Yeah, so the basic instruction there is get it, lock it in, and then who knows what the future brings, even if people aren't thinking of coming back right now.
Absolutely, yeah.
The second question is linked to that, which
just to add to that, what we're seeing is a couple of people have become nervous about creating settled status because they believe it's giving more data back to the government, especially those who have obtained either furlough money or some of the self-employed grants as well. Unfortunately, what was intended to be a good thing has actually disrupted the settled status process. That a number are sort of thinking, okay, if I've taken the grant, what if I just go home? They have to repay it. And so there's a bit of a panic around that as well.
Okay, yeah, so it's another fair point. This question here is, in terms of what we've got to do between January and June, clearly the regulations changed, but there's a 6-month period where people may or may not have settled status. What's our responsibility there? And what should we do if we suspect somebody may not have settled or pre-settled status?
Okay, so the starting point is, you say for example we're in January, the starting point is you need to establish when they entered the UK. If they entered the UK before the 31st of December, then you need to ensure that they apply for and obtain the pre-settled status by the 30th of June. If they've come after the 1st of January, then you wouldn't be able to employ them unless you have a sponsor license in place and they apply under the skilled worker visa route.
So the information you should be asking for is their ID. Initially, you'll only need their ID, whether they've got settled or pre-settled status, and if not, when they arrived in the country.
Correct. Yeah. Exactly.
Those three pieces of information. Should we take one more question? This one sort of, it's looking forward to the next stage, I guess, in terms of the movement of people. So, is it, if your employment is revoked, how does that change your, so somebody, I'm assuming this is somebody who's come in after settled and pre-settled status, so they're now a migrant worker. And how long do they keep employment? How long do they keep their status to remain if they no longer have a job?
All right. So the employer needs to notify the Home Office to let them know that the employment has been terminated. From the date of the notification, the employee is given a 60-day grace period before their visa is revoked. During that 60-day, they need to find alternative employment from a licensed sponsor. And then once they have the job offer and the certificate of sponsorship from the new licensed sponsor who's offering them new employment, they can then apply from within the UK to obtain a new skilled worker visa on the basis of their new employment.
Okay, that's brilliant. Thank you. I mean, there's another sort of comment here, and I think it is worth flagging it up. We've got reverse charge VAT, which is going to compound some of the issues around gangmasters VAT. If we hadn't run out of time, I'd have put that to Ian, and I reckon we could have had another hour out of him, because he is probably the most knowledgeable man I've ever met about IR35, reverse charge VAT, and again has been providing us with some brilliant support there. So thank you. But I think that's something we are coming back to. There is a letter, just to reassure people again, we have not given up on the reverse charge VAT, and there's another letter going into government signed by pretty much every organisation that I know in construction now that says please don't do this to us in April. So the industry is rallying against that reverse charge VAT. So I mean, to sort of conclude, really, there's as Nathan said, our fears are around inflation, our fears are around the potential of unscrupulous companies operating promises or operating systems that seem to solve your problems. And if it seems too good to be true, be careful. And so our sort of overriding message is be careful. And we are concerned about this, and there's little doubt it is going to change the way that we engage and train labour in the sector. If we had our way, it would be less of a hard edge in January and more of a roll in time, and we'll continue to have that conversation with government. In the meantime, we do have to look at how we develop and build our own workforce, and FIS is about to start our first pilot kickstart program, which is introducing new people to our sector through work experience. I'm delighted to announce today that the Build Back program, which is our unemployment onboarding and induction to bringing people out of unemployment and back and into our industry, has just received some funding, which means we can kickstart that again next year. It was a really successful campaign when we were running it pre-COVID, and we hope to get it back up to that level, because we need somewhere between 1,500 and 2,000 people every year, even if this stuff doesn't really hit us too hard. So again, there's, we are in a market where we know we've got an aging workforce, and we need to focus on these things. We've also got the new apprenticeship standard, and we're working across the UK to help build delivery and support those entities in delivering it, and delivering it well. So we've got the Brexit risk management toolkit, which is available to download from the website for members. Have a look through that. Again, and what we try to do is isolate where we think where we think your risks are and where our concerns are. If we're missing something, please feed it in, because that's a live document. We update it weekly, and as new problems come in from the membership or new challenges come in from the membership, then they'll get added to that list, and we'll look to find how we can help you resolve that, because our job is to make your lives easier. So we've got the next Brexit event next week on the 10th at the same time. I'd like to thank all of our speakers for the time they've given us today, and I'd like to thank you all for your attention, and stay safe, stay sane, and keep smiling. Thank you, everybody.
Thank you, everyone.